Welcome back to the deep dive. Today we're digging into a legal clash from, well, centuries ago, but one that surprisingly still shapes how we do business, even now in our super-fast digital world. We're focusing on Master v. Miller, a big case from 1791.
That's right.
So try to picture it. London, 1791, streets buzzing, maybe a bit muddy, ink everywhere, commerce is just exploding, right? Driven by this constant flow of credit. And imagine a piece of paper, a bill of exchange, getting passed around hand to hand, making trade possible across huge distances.
Absolutely vital pieces of paper.
But then someone, we don't even know who, subtly changes a crucial detail on it. A date, maybe?
A material detail.
Exactly.
Yeah.
And suddenly you've got an innocent buyer holding this altered bill, thinking it's good. You've got the person who originally agreed to pay saying, hang on, that's not what I signed.
And the fraudster, long gone.
Vanished. So this tiny change lights this massive legal fire, and the echoes are still with us.
It really is a fascinating turning point. And our mission today for this deep dive is to unpack this decision. We want to get into the historical context, which is crucial, understand the tough spot the courts were in,
Right.
and then trace how its influence lasted. And you'll see its core ideas, they still guard everything from, the checks you might still write occasionally, to even complex things like smart contracts on a blockchain.
Wow.
Yeah, it really boils down to this fundamental tension. How do you protect the trustworthiness of documents, but also keep commerce flowing smoothly? It's a balancing act.
Okay, so let's paint that picture a bit more. 1791, England. It's easy to think, oh, olden days, feudal times maybe, but no.
Not at all. This was the heart of what historians call the Georgian commercial revolution. The economy was transforming like crazy. International trade was booming. Banking was getting sophisticated.
And credit, you mentioned credit.
Credit was everything. It was this dynamic, fast-moving commercial world.
So what was making it all tick? You mentioned bills of exchange.
Yes, exactly. They were the absolute lifeblood of this new economy. These weren't just simple IOUs, they were what we call negotiable instruments. Meaning they could be bought and sold, passed from person to person, almost like cash. And the new holder got the right to demand payment, even if there were, say, disputes between the original parties. This free transferability, this negotiability was key.
So they moved fast.
Incredibly fast, across huge distances sometimes. And the scale is, well, it's kind of mind-boggling for the time. By 1791, these bills of exchange made up over 60% of all commercial deals in London's merchant circles.
60%.
Over half. Think about that. More than half of business depended entirely on people trusting these bits of paper.
That's incredible reliance. But okay, here's the problem, right? The legal system hadn't quite caught up.
Well, it was trying, but it was heavily anchored in centuries-old precedents, as you said. The big one here was Pigot's case, came way back in 1614. And that case basically said, look, if you alter a sealed deed, and back then, deeds were the serious documents if the person it benefits alters it at all, it's void. Finished.
Harsh.
Very harsh. And even if a stranger made a material alteration, that could void it too. It reflected real worries about proof and document integrity when things were simpler, sealed with wax,
So how could that old rule possibly work for these fast-moving bills of exchange? They weren't sealed deeds.
Exactly. That was the tension. How do you apply ancient deed law to this dynamic, constantly circulating commercial paper? The courts had to find an answer. And the answer they came up with would really set the course for commercial law for ages.
All right, so with that context, let's zero in on the actual case, Master v. Miller. Let's meet the players. It's like a classic legal setup.
It really is.
First, you get defendant Miller. He's the acceptor. He signed the bill, agreeing to pay a certain amount after date. He saw it, signed it in its original state.
Crucially, yes.
Then later, someone alters it. He had no knowledge of that alteration. So when he gets sued, his argument is simple. That altered thing, not my contract.
Makes sense from his perspective.
Then there's plaintiff master. He's the holder, an innocent holder for value.
Key phrase.
Meaning, he bought the bill, paid good money for it, completely unaware of the alteration. He just thought he had a valid debt and wanted to get paid.
He acted in good faith.
And pulling the strings, somewhere off stage, is the unknown fraudster. We don't know who. But this person, without permission, fraudulently altered the date.
And not just any changing the date made the payment due earlier, it materially changed Miller's obligation.
Right. So Master sues Miller. And the big legal question becomes...
It boils down to this.
All right.
If someone makes an unauthorized material change to a negotiable instrument, does that kill the instrument completely? So completely that nobody can sue on it, not even an innocent buyer like Master who paid value for it.
That's the core dilemma.
Absolutely. And it forces the court to weigh these two huge policy goals that, honestly, we still grapple with in commercial law. First, protect the document itself. Protect its integrity. Stop fraud. You shouldn't be forced to pay on terms you never agreed to.
Makes sense.
But second, you need to protect innocent buyers. You need to keep credit flowing. That whole system of negotiability relied on people like Master feeling confident that the paper they bought was good.
So protect the paper versus protect the flow of commerce.
In a nutshell, yes. And the stakes were incredibly high. Whatever the court decided here wouldn't just settle this one dispute. It would create the rules for judging alterations on all negotiable instruments everywhere the common law reached. Huge implications.
So how did the court, the King's Bench, handle this? Where did they start?
They started, maybe predictably, with that old case, Pigot's case from 1614, that harsh rule about alterations voiding deeds. And the Chief Justice, Lord Kenyon, he really laid out the policy thinking behind sticking to a tough line. He famously said, "No man should take the chance of committing a fraud without running any risk of losing by the event when it is detected."
Meaning, if you tamper, you lose everything, even if you almost get away with it.
Exactly. It's about deterrence. Make the penalty severe and certain so people don't even try tampering. Especially important back then when, checking for forgeries was basic, to say the least.
Okay, so deterrence is key. But bills weren't deeds. How did they bridge that gap?
That was the crucial step. The court basically reasoned that these newfangled negotiable instruments, because they were so important and relied upon, needed the same level of protection against alteration as traditional deeds.
Ah, I see.
So they extended the Pigot rule. They said this harsh approach applies to all written instruments, including bills of exchange. The policy reasons preventing fraud, ensuring certainty, were just as strong, maybe even stronger, given how widely these things circulated.
How did they explain that legally, though? That the altered bill just wasn't Miller's anymore?
They used something called the identity theory. The logic was, deceptively simple. The altered document was no longer the same contract the defendant had accepted. It had changed its identity.
Right.
And Justice Gross, one of the judges, connected this really cleverly to an old common law defense called non est factum.
Latin for?
It is not my deed. Or, in this context, it is not my act, not my contract. By changing it materially, the fraudster destroyed its legal identity. So Miller could truthfully say, that thing you're suing me on, non est factum, it's not the contract I made.
That's quite elegant in a way.
Yeah.
It links the new problem to old principles.
It does. And it's interesting how the different judges emphasize slightly different things. You had Lord Kenyon laying down that strong moral and policy line about deterrence.
Right, the no man should take the chance guy.
Exactly. Then Justice Ashurst, he focused more on the idea of custodial obligations. Like, if you hold this important piece of paper, you have a duty to keep it safe, keep it unaltered.
A duty of care for the document.
Sort of, yes. And Justice First, as we said, he provided the neat doctrinal link with non est factum, grounding it in established legal theory.
And there was one more, Buller.
Justice Buller, yes. He agreed with the result, but he apparently used his judgment to sort of critique other areas where the common law was maybe too rigid, almost signaling, okay, we're holding the line here, but maybe the law needs to keep adapting elsewhere for commerce.
So a complex decision, but they reached a consensus.
A unanimous one, in fact.
So the final verdict. For Master, the innocent holder.
Bad news for Master. Judgment for the defendant, Miller. The court ruled that the material alteration completely voided the bill of exchange. Master, despite being innocent, despite paying value, couldn't recover a penny from Miller.
Wow, that is harsh.
It is. And just to cement it, the decision was appealed to a higher court, the Court of Exchequer Chamber, and they upheld it. Same harsh result.
So this cemented the material alteration doctrine. Can you recap what that doctrine essentially says?
Sure. It means any unauthorized change that actually affects the legal obligations in the instrument, changing the date, the amount, when or where it's paid, who the parties are, that kind of significant change makes the instrument void, kaput.
Regardless of who did it.
Regardless of who made the change, fraudster, stranger, doesn't matter. And critically, regardless of whether later holders, like Master, were acting in good faith and had no idea.
So absolute no distinction for innocent holders.
None whatsoever at this stage. The court's logic was stark. The altered paper simply wasn't the contract Miller agreed to. End of story.
It feels like a very bright line rule. No gray areas.
Exactly. Certainty above all else. The courts basically said, we're not getting into messy arguments about who was at fault or what's fair in this specific case. If it's materially altered without consent, it's void, period.
Okay, so the law is clear, but how did the actual business world react? The merchants on those London streets.
Well, the reaction was definitely mixed. On the one hand, yeah, it gave them very clear guidance. And the strong message against fraud, the deterrence, that was probably welcome in many quarters.
Right.
But it undeniably created big risks for innocent people caught in the middle. Think about it suddenly. Every merchant, every banker had to be extra careful about examining every single bill that came across their desk.
Lowering things down.
Potentially, yes. It definitely forced a serious rethink about, due diligence, how carefully documents were handled, maybe even who you accepted paper from. Certainty came at a cost to the speed and perhaps the trust that fueled the system.
So this strict rule from 1791, did it just stay frozen like that forever? Commerce kept evolving, right?
It did keep evolving, and thankfully the law eventually adapted too, although it kept the core of Master v. Miller.
How so?
The big step came much later in Britain with the Bills of Exchange Act 1882. Parliament stepped in. Section 64 of that act essentially codified the Master v. Miller doctrine, put the court's rule into formal legislation.
So it kept the main idea.
It kept the core principle: material alteration voids the instrument. But it added some really important refinements, softening the edges a bit.
Like what?
Well, for one, it actually defined what counts as a material alteration more clearly, changes to date, sum, time or place of payment, interest rate. That brought more certainty.
Okay.
It also explicitly added a consent exception. If all the parties liable on the bill agree to the change, then it's fine. That just makes sense. Parties should be free to change their own agreements.
Right.
And here's the really big one: holder and due course protection. This was a crucial innovation. It created a special status for certain innocent holders who meet specific criteria, basically, super innocent holders.
Holder in due course. Okay.
And the act said, if the alteration is not apparent, you couldn't tell just by looking at it, then a holder in due course can still enforce the bill.
Oh, wait. Enforce the altered bill?
No, not the altered terms. They can enforce it according to its original tenor, meaning according to the terms before it was altered.
Ah. So in our case, Master, if he qualified and the date change wasn't obvious, might have been able to sue Miller for the original amount payable on the original date.
Exactly. It was a major step towards balancing that need for document integrity with the practical needs of commerce. Really important compromise.
And did this idea spread?
Oh, yes. Similar laws, similar codifications popped up all over the common law world, and that eventually led to the Uniform Commercial Code, the UCC, in the United States, specifically Article 3, which deals with negotiable instruments.
And the UCC.
The UCC represents probably the most significant modern evolution. It builds on the 1882 Act, further refining things, maybe softening the rules a little more in certain situations, but always keeping that Master v. Miller foundation intact.
It's amazing how that one case keeps echoing. So fast forward to today. Why should someone listening now, maybe dealing with contracts or payments, still care about a 1791 English case?
Because Master v. Miller, or at least the principles it established, are still absolutely vital. They're woven into the fabric of modern commercial law.
How so? Where does it pop up?
Courts today still regularly refer back to it, or the doctrines it spawned, when they're looking at altered checks, promissory notes, you name it. That core idea, material alteration, discharges the person who is supposed to pay. That still shapes how fraud cases and commercial disputes get resolved.
And the UCC, Article 3, those refinements you mentioned?
Yeah, the UCC has built on it significantly. For instance, it makes clear distinctions now between alterations made with fraudulent intent and those that aren't.
Okay.
It reinforces that ability for a holder in due course to enforce the original terms in many situations. And importantly, it brings in concepts of negligence.
Negligence, how does that fit?
Well, the UCC says if your own carelessness substantially contributed to the alteration being made, maybe you left huge blank spaces on a check, making it easy to change the amount, you might be stopped from using the alteration as a defense against someone who paid in good faith.
Ah, so your own sloppiness can come back to bite you.
Exactly. It adds another layer of nuance beyond the strict rule of 1791.
And what about the digital world? Electronic payments, digital documents? Does Master v. Miller have anything to say there?
It's fascinating, actually. While the form is totally different, courts often apply analogous reasoning. If an electronic record, say a digital promissory note, is altered without authority, the same fundamental questions arise.
Like, is the digital integrity compromised? Is it still the same instrument?
Precisely. Of course, proving a digital alteration requires, sophisticated forensic analysis Lord Kenyon couldn't have dreamed of. But the underlying principle that a material, unauthorized change can fundamentally affect enforceability still resonates.
So if you're dealing with financial documents today, paper or digital, what's a practical takeaway? Like a mini checklist based on this history.
Yeah, you could think of it like a practice alert, rooted in Master V. Miller's legacy. First, identify potential alteration. Look closely. Is the ink weird? Are figures overwritten? Erasures? Any digital anomalies?
Step 1, vigilance.
Step 2, determine materiality. Does the change actually affect the core legal obligations? Date, amount, payment terms. These are almost always material.
Okay.
Step 3, investigate authorization. Was this change agreed to? Did everyone liable sign off on it?
Consent is key.
And step 4, assess holder status. If there's an alteration, who's holding the instrument now? Do they qualify for special protection, like a holder in due course under the UCC?
Right. Identify materiality, authorization, holder status.
Those 4 points really flow directly from the problems and solutions hammered out, starting way back with Master V. Miller. It taught the commercial world that details matter, integrity matters.
It really feels like Master V. Miller created this lasting synthesis of ideas, principles that somehow still work even as technology races ahead.
I think that's right. You can trace this clear line. Pigot's case back in 1614 setting a harsh baseline. Then Master v. Miller in 1791 applying it broadly to commerce. Then the Bills of Exchange Act in 1882 codifying and refining it. Then the UCC Article 3 in the U.S. modernizing it further. And now it's digital evolution today.
Through all that change, what are the absolute core timeless principles that endure for Master v. Miller?
I'd say there are 3 main ones. 1, document integrity is paramount. People have to be able to trust the written or digital word they agreed to.
Okay.
2, deterring fraud requires real consequences for tampering, making it risky, as Lord Kenyon said, even if detection isn't guaranteed.
Right.
And 3, commercial necessity demands balance. You have to offer some protection to good faith participants to keep the wheels turning, but within a system that maintains overall trust, integrity, deterrence, and balanced protection.
And it all comes back to that quote from Lord Kenyon, doesn't it? No man should take the chance of committing a fraud without running any risk of losing by the event when it is detected. Still sounds pretty wise today.
It really does. From those handwritten bills of exchange to today's encrypted digital assets, the tools of commerce have changed almost beyond recognition. But Master v. Miller is this constant reminder that the foundation's trust, integrity, accountability, they're kind of eternal, and makes you wonder, what challenges will the next technologies bring?
Yeah.
AI-driven contracts, maybe quantum computing affecting encryption. How will these bedrock principles hold up? How do you think they'll need to evolve?
That is definitely something to think about. What a fascinating journey back in time with such clear relevance for today. Thanks for joining us on this deep dive. Keep exploring, keep questioning those foundations.